Okay, let's jump right into this. Today, we're doing a deep dive into India's foundational environmental legislation, the Water Act of 1974, and the massive, really fascinating modernizations it's undergoing right now. We're looking at a legal framework that literally shapes the health and daily lives of over 1 billion people.
So think about it. How does a nation protect its vital water resources while simultaneously accelerating a massive economic engine? It's a huge challenge, right? Every rapidly developing nation faces this exact tension. How do you keep streams and wells safe without wrapping your industries in so much red tape that they just can't function? Well, this explainer is going to visually map out exactly how India's recently amended law attempts to walk that tightrope.
Here is our roadmap for today. 1. Modernizing India's Water Act. 2. Regulators, central and state boards. 3. The industrial consent mechanism. 4. Decriminalization and monetary penalties. And 5. Public interest and stakeholder duties.
Let's kick things off with Section 1, Modernizing India's Water Act, Balancing Wholesomeness with Growth. For decades, a single word has essentially driven India's environmental mission, and that word is wholesomeness. The original 1974 Act was designed with this ultimate, foundational goal in mind: preventing contamination and restoring the physical, chemical, and biological purity of water across the entire country. But as the decades passed, the way this wholesome standard was enforced really needed to adapt to a modern, fast-moving economy.
And that brings us to the 2024 amendment, which introduces a totally massive shift toward rationalized enforcement. The government essentially recognized that treating a minor paperwork error the same as a massive toxic spill just wasn't efficient. So, by decriminalizing minor offenses, this new framework embraces what they call trust-based governance. The whole idea is to increase the ease of doing business, but without sacrificing those foundational environmental goals we just talked about.
Moving on to Section 2, Regulators, Central and State Boards, the two-tiered management structure.
Now, India's water management relies on a very strict division of power. It's actually really helpful to think of the Central Pollution Control Board, the CPCB, as the architects. They are the ones advising the central government, setting the national standards for water quality, and stepping in to resolve disputes between states. On the flip side, you have the State Pollution Control Boards, or SPCBs, acting as the inspectors on the ground. They handle state-level planning, review treatment plants, and directly manage the day-to-day enforcement by inspecting factory effluents.
But here's where it gets interesting. The 2024 updates drastically alter this dynamic by giving the central authority a lot more muscle. Previously, state boards could be pretty fragmented in how they applied the rules. Now, the central government, in crucial consultation with the CCPB, can issue specific guidelines that are strictly binding on the state boards. This is a big deal because it strengthens central oversight and closes up those fragmented regulatory loopholes.
Let's look at Section 3, the industrial consent mechanism, the rules of engagement for businesses.
You can think of this mechanism as the ultimate environmental toll booth. If an industrial occupier is planning to discharge any trade effluent or sewage into a stream, a well, a sewer, or even just onto land, they cannot even begin to pour the foundation without getting a consent to establish. And once the facility is built, they absolutely cannot turn the machines on without a consent to operate.
To manage this, industries are categorized using a really intuitive traffic light system based on their pollution index. If you are a red category industry, meaning highly polluting, you're facing severe restrictions. We're talking strict oversight and mandatory 500-meter distances from any surface water bodies. Orange has moderate oversight with 30 to 75-meter distance requirements. Green is standard compliance for low-impact industries, and then there's a blue category for specific essential environmental services. Basically, your color dictates your fees, your location, and the level of scrutiny you're going to face.
But here is the real game changer for modernization: the creation of a white category. The recent amendments allow the central government to completely exempt certain low-pollution sectors from these strict consent requirements entirely. We're looking at operations like air cooler manufacturing, bicycle assembly, or solar power generation. With just a simple written notification to the state board, they bypass the heavy bureaucratic toll booth completely. It's a massive boost for the ease of doing business in clean industries.
And for the businesses that do still need consent, the rules have been incredibly streamlined. Check out this massive change from the 2026 amendment updates. Previously, businesses had to constantly go back and renew their consent every 5 to 15 years, depending on their color category. Now, once your consent to operate is granted, it remains valid indefinitely as long as you don't violate the conditions. It literally slashes bureaucratic red tape for compliant, law-abiding businesses.
Section 4. Decriminalization and monetary penalties. The 2024 paradigm shift in enforcement.
So instead of facing immediate jail time, failing to comply with general state board directions now hits you directly in the wallet. The fines range from 10,000 all the way up to 15 lakh rupees. This right here is what they mean by trust-based governance in action. If you fail to comply with a standard rule, you face a substantial financial penalty rather than being immediately dragged into criminal court.
Now, to be clear, decriminalization absolutely does not mean deregulation. If you keep violating a rule, you get hit with a continuing offense penalty of 10,000 rupees every single day. And the serious offenses, like sneaking around and operating a polluting factory without that mandatory Section 25 consent, that still carries a severe punishment of 1.5 to 6 years in prison. Even government departments are held accountable. Get this, an offending department head can be personally fined an entire month's basic salary, unless they can prove the violation happened completely without their knowledge.
To handle this whole new financial penalty system, the central government now appoints adjudicating officers. These are high-ranking officials, not below the rank of joint secretary, who conduct inquiries and impose the fines. It's actually a brilliant move, because it removes the immediate burden of minor environmental infractions from India's heavily backlogged criminal courts. And of course, if you disagree with the officer's fine, you still have the right to appeal directly to the National Green Tribunal.
Finally, Section 5. Public interest and stakeholder duties, accountability in the new ecosystem.
Ultimately, this entire system is designed around public health, specifically prohibiting poisonous matter from entering primary sources of drinking water. But under this modernized act, the system isn't just designed to punish, it's built to reinvest. All those new monetary penalties we talked about, they actually get credited to the Environmental Protection Fund to pay for real-world conservation efforts. On top of that, transparency is absolutely mandated. State boards have to keep a public register of consent conditions open for inspection, and literally any citizen can step up and file a complaint with an adjudicating officer if they spot a violation.
For the industries, the project proponents, the reality of compliance is now heavily digitized. You aren't just handing in stacks of paper forms anymore. You submit self-certified applications through a unified national online portal. Plus, you can now engage authorized third-party registered environment auditors to verify your consent applications and conduct site inspections. It heavily shifts the onus onto the industry to properly install and constantly maintain their pollution control equipment, which fosters a much stronger culture of self-regulation.
And there's a huge bonus for micro and small units. For them, this trust-based model is incredibly empowering. If you are setting up your shop inside a pre-approved, notified industrial estate, the moment you submit your self-certified application on that portal, your consent to establish is deemed automatically granted. You can start building right away. There's no waiting around for months for an inspector to stamp a piece of paper.
So I'll leave you with this. Does replacing automatic prison sentences with monetary penalties truly balance industrial growth with the long-term wholesomeness of India's water? It is a really provocative question to think about as we watch this newly modernized ecosystem unfold in the real world. Can financial penalties effectively deter pollution, or will some industries just start treating them as a regular cost of doing business? The framework is clearly designed to be faster, smarter, and more unified, focusing the heavy hammers on the absolute worst offenders while giving clean, small businesses the room they need to thrive. Thanks for joining me on this deep dive into the modernization of India's Water Act. Keep learning, keep questioning, and I'll catch you in the next explainer.